The asphalt shoulder of a highway is a stage, and unfortunately, most drivers have been memorizing all the wrong lines. The common sense you've picked up from movies, legal forums, and water cooler talk is often a direct script for a legal disaster. Most people believe they know their rights, but in reality, they are walking straight into traps set by their own misconceptions. Today, we're going to systematically dismantle 10 of the most dangerous lies about police and traffic stops that people fall for every single day. What you think is a clever legal loophole might actually be the very thing that fast-tracks you into a pair of handcuffs. Let's get into the truth before your next commute turns into a court date. Number 1. The golden ticket fallacy. Miranda rights. We've all seen it on TV. The detective snaps the cuffs on the suspect and immediately begins reciting, "You have the right to remain silent." Because of this, a massive myth has taken hold. If an officer forgets to read you your Miranda rights during an arrest, the case is automatically thrown out. You win, they lose, right? In reality, this is a total misunderstanding of the law. Miranda rights are specifically required only before a custodial interrogation. This means police only have to read them if you are in their custody and they intend to question you to obtain a confession or incriminating evidence. They can legally arrest you, process you at the station, and throw you in a cell without ever mentioning your right to remain silent. The only real-world consequence of a Miranda failure is that any statements you made during questioning cannot be used as evidence in court. However, the physical evidence, witness testimony, and the officer's own observations remain perfectly valid. Don't expect a clerical error to be your get-out-of-jail-free card. Number 2. The undercover truth trap. There is a persistent, almost comical belief that if you ask a person, "Are you a cop?" they are legally obligated to tell you the truth. People think this is a secret legal loophole that protects them during shady dealings. This idea exists only in poorly written spy movies and the final thoughts of people being led away in chains. The entire point of undercover work is deception. If an officer's job is to infiltrate a criminal ring or conduct a sting operation, the law does not require them to blow their cover just because you asked a question. Asking a cop if they're a cop is like asking a magician to show you the false bottom of their hat. They're going to say no with a straight face. In fact, asking the question does the officer's job for them. It signals that you are likely engaged in something illegal and have reason to be paranoid. Number 3. The honesty is the best policy confession. Do you know why I pulled you over today? It sounds so casual, almost like a friendly quiz. Your brain starts racing and you think that if you're just honest, admitting you were doing 50 in a 35, the officer will appreciate your candor and let you off with a warning. Stop right there. You are walking into a trap. This question isn't a test of your character, it's an invitation to provide a recorded confession. The moment you say, "I guess I was speeding a little," you have handed the prosecution their opening statement. You've turned a situation where the officer might have had to prove your speed into one where you've admitted guilt on the record. The most effective response is a polite, "No, officer, I'm not sure." Don't do the detective work for them. Number 4. The flow of traffic philosophy. You're cruising at 85 miles per hour in a 65 mile per hour zone, but so is everyone else. You feel safe because you're just going with the flow. When the sirens start wailing behind you, it feels like a personal betrayal. Surely explaining that you are simply being a predictable driver by keeping pace with the herd will work, right? Wrong. The flow of traffic defense is a piece of driver's lounge philosophy that evaporates the moment it hits the courtroom. The officer didn't pull over the entire highway, they pulled over you. In the eyes of the law, you were a convenient, single-serving example of a violation. To the police, you weren't flowing, you were speeding. Everyone else on the road is just future revenue that managed to get away this time. There is no legal safety in numbers when it comes to the radar gun. Number 5. The quick look consent search. Mind if I'd take a quick look in your trunk? It sounds like a casual request between neighbors, but it is a high-stakes legal maneuver. If the officer had probable cause to search your car, they wouldn't be asking. They'd be searching. The very fact that they are asking means they need your permission to bypass your Fourth Amendment rights. Your Fourth Amendment right allows you to draw a firm, bright line. A simple, polite, "Officer, I don't consent to any searches," is your best defense. Consent is the fastest way to turn a routine 5-minute traffic stop into a 2-hour fishing expedition. Furthermore, consent has scope. Just because you let them look in the trunk doesn't mean you've given them the right to open locked suitcases or sealed boxes inside that trunk. However, once you say yes to any part of it, you've opened a door that is very hard to close. Exercise your rights. They aren't signs of disrespect. They are constitutional. Number 6. The home base sanctuary myth. You see the flashing lights in your rearview mirror, but you're only half a block from your house. A movie-inspired plan takes root. If you can just make it into your driveway, you're safe on private property. You swerve into your spot, kill the engine, and dash for the front door like you're playing a game of tag. The reality check usually comes when you're tackled on your own lawn. Your driveway is not a legal sanctuary. Police are legally allowed to follow you onto private property to complete a lawful traffic stop under the doctrine of hot pursuit. By trying to reach base, you haven't outsmarted the system. You've just upgraded a $150 speeding ticket into a felony charge for fleeing and eluding. That dash for the door could cost you thousands in legal fees and potentially a jail sentence. Number 7. The "I pay your salary" nuclear option. The officer is writing the ticket, and you decide to pull out the ultimate weapon of the entitled driver. You look them in the eye and utter the forbidden phrase, "I pay your salary." You expect this to trigger a sudden wave of civic humility, causing the officer to apologize and tear up the citation. In reality, the only thing you've triggered is a massive internal eye roll. This line is the nuclear option of bad ideas. It instantly transforms you from a regular citizen who made a mistake into an arrogant antagonist. Mathematically, your specific tax contribution might cover the cost of the ink in their pen, and after that comment, the officer will be happy to use every drop of that ink to ensure your ticket is filled out with meticulous, unforgiving detail.
Number 8. The field sobriety circus. Panic sets in when an officer asks you to step out of the vehicle to perform a few simple tests. You think, "I have to do this or I'll look guilty." So you find yourself trying to walk a straight line on a sloped shoulder while cars whiz by at 70 miles per hour. Here's the cold, hard truth. Field sobriety tests, FSTs, are almost entirely voluntary in most jurisdictions. They are not pass-fail exams. They are evidence-gathering exercises designed for you to fail. Factors like nerves, uneven pavement, medical conditions, or just plain bad balance can make a perfectly sober person look impaired. Agreeing to stand on one leg like a drunken flamingo doesn't prove your innocence. It provides the prosecutor with a neatly edited video of you at your most uncoordinated. Refusing the test might still lead to an arrest, but it prevents you from starring in the state's evidence reel. Number 9. The clerical error loophole. You get the ticket and notice a tiny mistake. The officer wrote that your car is silver when it's clearly charcoal metallic, or perhaps they misspelled your middle name. You think you found the magic loophole that invalidates the entire charge. You march into court ready for a triumphant dismissal. The judge will likely listen to your declaration, sigh, and then allow the officer to amend the ticket on the spot. Minor clerical errors that don't change the core facts of the violation, that a specific person was driving a specific car at a specific time, are legally irrelevant. Unless the error makes it impossible to identify the person or the offense, a typo is just a typo, not a get-out-of-jail-free card. Number 10. The emergency flasher shield. The Park Anywhere button, also known as your hazard lights.
People believe that as long as those lights are blinking, they can legally park in fire lanes, no parking zones, or the middle of a busy street to just grab a coffee. In reality, those lights are a beacon that screams, "I know I'm breaking the law." Hazard lights are for roadside emergencies, such as mechanical failure or a flat tire. Using them for convenience doesn't create an invisible shield of legality. It actually makes you a target. To a passing officer, you've just put a neon sign on your car that says, "Ticket me first." It doesn't stop the citation, it just helps the officer find your car faster in a crowded area. The side of the road is no place for legal theories or tricks you heard on a forum. When those lights go on, your only goal should be to end the interaction safely, politely, and with as little incriminating evidence against you as possible. Remember, the place to argue about radar calibration, flow of traffic, or the color of your car is a courtroom, where there are rules of evidence and a judge who can actually make a ruling. On the shoulder of the highway, you aren't negotiating. You are generating exhibits for your own trial. Stay calm, stay quiet, and stay safe.